Hey folks, buckle up because today's Judiciary Committee hearing was a wild ride. Senator John Kennedy didn't just show up. He brought a storm with him. 3 judicial nominees were in the hot seat: Mr. Papillion, Judge Hurson, and Mr. Daniel. And let me tell you, it was anything but a routine day. Kennedy came prepared, asking questions that cut right to the bone. Let's dive into the highlights, or should I say, the grilling moments. First up was Mr. Papillion. Kennedy leaned in and asked him to define a motion in limine. Don't worry if you're scratching your head. It's a bit of a legal deep cut. Papillion stayed calm and explained it's a pre-trial motion for rulings on evidence. Kennedy wasn't trying to trip him up, just testing his precision.
Thank you, Mr. Chairman. Congratulations, gentlemen. Mr. Papillion, tell me the definition of a motion in limine.
A motion in limine, in some law books it doesn't exist, Senator, but what it is it is a motion filed in advance of trial to get a ruling in limine, which means in advance of some issue that may come up in the trial, usually an evidentiary issue.
I thought you might know.
Thank you.
Judge Hurson, explain to me the various definitions that the U.S. Supreme Court has used to define a fundamental right.
Next, it was Judge Hurson's turn, and things got philosophical. Kennedy wanted to know how the Supreme Court defines a fundamental right. Hurson explained. It must be deeply rooted in tradition, implicit in ordered liberty, and clearly defined. Kennedy pushed further, referencing landmark cases like Anne. It was clear this was about more than answers. It was about understanding judicial philosophy. Kennedy then circled back to with its concept of rights in the penumbras of others. Hurson acknowledged the debate, noting these rights aren't explicitly stated but recognized by the court.
In Glucksberg, and even recently in Dobbs, the Supreme Court has really focused on 2 major issues. One, whether the right in question is deeply rooted in our history and tradition. And the court is also focused on whether it is implicit in the concept of ordered liberty. And I also believe that in Glucksberg they describe the need for the right to be clearly defined.
How does that relate to the discussion in Griswold of a penumbra?
Well, obviously, Griswold, as you state, points out this concept of the penumbra, rights that are not explicitly enumerated, but that the court has otherwise found. As a sitting magistrate judge, and if I was fortunate to become a district judge, I would, of course, follow the guidance of the Supreme Court, who has identified just a few, relatively small number of those rights. Obviously, the right to privacy, perhaps being the most well-known.
Well, can you have, what has the Supreme Court said about the existence of a fundamental right that is not part of our history and tradition? For example, when the court delved into the Second Amendment, it was really, the opinions were almost written as if they were historians as opposed to judges, but part of our history and tradition was a fundamental part of their discussion.
Kennedy's core question lingered. If a right isn't historical, how can it be fundamental? Finally, it was Mr. Daniel's moment under the spotlight. Kennedy posed a tricky scenario about police stops. Daniel confidently replied about needing reasonable suspicion, but Kennedy threw in a curveball about roadblocks. Daniel admitted he was unsure, highlighting how legal principles can sometimes be a tangled web. And there you have it.
Does a right have to be part of our history and tradition to be fundamental?
Well, I can say this, that in Heller, McDonald, and Bruin, that was the focus. That's what the court looked at. Now, there are other cases throughout history that have recognized a few other rights, the right to marry, for example. And I can't speak to the specific methodology that was used, but I will say, at least in the Second Amendment context, that focus on history was critically important.
Okay. All right. Let me move to Mr. Daniel. Can a police officer well, let me try this another way. If I'm walking down the street and a police officer wants to stop and talk to me, can he just stop and talk to me for any reason?
Senator, you can seek your consent to stop and talk to you.
What if I don't consent?
If you don't consent, then the officer needs to have a reasonable articulable suspicion that a crime has been committed, will be committed, and be able to articulate that to justify the stop.
Okay. Then how come police officers can set up a roadblock and stop 500 people to see if they have liability insurance?
My understanding is that the Supreme Court has ruled that those types of stops, when generally applied, are conducive to good order and policing.
Why? They're still stops, aren't they?
Senator, in my 8.5 years as a prosecutor, I've not had to litigate the adequacy.
I know. I'm just asking you what you think. I mean, isn't that pretty intrusive? What if I'm in a hurry to pick up my kid from school and I don't have time to wait for 10 minutes? And I don't want to wait anyway. Why? If a cop can't just stop me on the street, why can they stop me and check my insurance?
Senator, as far as my personal belief, I haven't encountered that.
I'm just asking you legally, why can they do that?
Again, I haven't encountered that issue, so I don't have the research on that, Senator.
Okay. Thank you. Thank you, gentlemen.
Senator Welch?
Kennedy's questioning wasn't just a formality, it was a revelation, an exposure of judicial thought. If you found this breakdown insightful, do me a favor, hit that subscribe button. I'll keep bringing you the nitty-gritty from Washington with all the drama you can handle. Catch you in the next one.